Well, as we always do, once we are now through with the general rule, we have to switch to the exceptions. Not yet the general exceptions that will apply to all WTO provisions, which will be subject to our next lecture. But now we need to talk of those specific exceptions which will apply to national treatment obligations. However, I'd better not call those exceptions, but exemptions. You will see the difference in wording once we go through the slides. And there is a little legalistic difference here that needs to be kept in mind. However, fundamentally, those will be the provisions that permit non-compliance with national treatment. So you remember that there were exceptions in Article 2, anti-dumping countervailing duties, border tax adjustments, charges and payments that are commensurate to the costs for services rendered. You remember there were specific exceptions that would apply to Article 1, and we mentioned regional trade agreements and the enabling clause provisions. And now it's time for us to, there were exceptions to Article 11, permissions to use quotas. We mentioned a number of provisions, including safeguards, the general exceptions, balance of payment matters. So you can get back to those lectures and recall those provisions if you, for whatever reason, don't recollect it immediately. However, now our focus is national treatment, and we need to understand how national treatment provisions can also be not complied with. And there are actually two provisions which permit non-performance of national treatment obligations as embedded in Articles 3.2 and 3.4, which we discussed. And those are in Article 3.8. In the course of this lecture, I once again highly invite you to follow the text, to make your marks in your own copy of the text, because it will greatly help you during the exam and resolving the cases once the exam time comes up. So, as I said, those exceptions are enshrined in Article 3.8. And there are actually two parts of it, 3.8a and 3.8b. So our task now is to address both in order. Let's first read both provisions. 3.8a. The provisions of this article, Article 3, National Treatment Obligations, shall not apply to laws, regulations, or requirements governing the procurement by governmental agencies of products purchased for governmental purposes and not with a view to commercial resale or with a view to use in the production of goods for commercial resale. So we understand that here we talk about government procurement, the purchase of products by governmental agencies, not with a view to commercial resale for the fulfillment of state, municipal, whatever purposes, public purposes, and not with a view to resell it or to use it in those products that will be resold further. So this is one exception when you do not need to provide national treatment to foreign products. Here you can discriminate against imported products. Foreign products can be put at a disadvantage with respect to government procurement. And B, the provisions of this article shall not prevent the payment of subsidies exclusively to domestic producers, including payments to domestic producers derived from the proceeds of internal taxes or charges applied consistently with the provisions of this article, and subsidies effected through governmental purchases of domestic products. So here we have the second exception, which is subsidies. Subsidies paid exclusively to domestic producers. The second part of this provision is less interesting for us. It starts with the word including, so it's just an illustrative provision. The second half of it, just the illustrative part. So fundamentally, to understand what the exemption is, you can read just the first two lines. The provisions of this article shall not prevent the payment of subsidies exclusively to domestic producers. So here is how WTO dispute settlement body approached this article 3.8. The panel report, Brazil taxation, reads as follows. Article 3.8a states that the provisions of this article shall not apply to government procurement, whereas by contrast, Article 3.8b states that the provisions of this article shall not prevent the payment of subsidies exclusively to domestic producers. So here they say shall not apply, shall not prevent. Here we would have a little difference. It's rather legalistic, but it's for our feeling how it actually works. And actually it is important because if something is an exception, we will talk about that in more detail once we talk of Article 20. If something is an exception, it's a very legal approach, but still, if it's an exception, then it's for the respondent, for the responding party, to make reference to this exception and to bear the burden of proof of the elements that are expected within that exception. If it is an exemption, if it's a right, then it's not the respondent that has to provide evidence and bear the burden of proof, but it's the complainant who will have to address these matters as well. So it's a legalistic matter, but therefore maybe we don't focus on it that much. It is more for dispute settlement and the allocation of the burden of proof. But here I would just like to mention the difference between the exception and the exemption. So as for Article 3.8a, discrimination resulting from government procurement is completely exempt from the application of Article 3. So it's the right that each WTO member has. So Article 3.3 just simply doesn't regulate those matters. Article 3.8 stands for the more limited proposition that the national treatment obligation does not extend to or prohibit the act of limiting subsidization only to the domestic producers, to the exclusion of foreign producers. So here the difference is between this exception and exemption legal approach. We clearly understand that 3.8a, government procurement, is an exemption, so it is just not completely not subject to disciplines of Article 3. As far as Article 3.8b says, shall not prevent, it is more likely to be treated as an exception of from the provisions of Article 3.8. From Article 3, generally from Article 3, because nothing in this article shall prevent, as the text reads. So again, repeating it in a different case, Canada feed-in tariffs, we agree with the European Union, that's what the panel says, that Article 3.8a is a scope provision rather than exception. So it determines the scope of national treatment obligation. It's not a carve out. Well, it is a carve out in a way. It is not. It is not an opposite rule. It is not a rule that somehow should be opposed to Article 3. It just determines the scope of its application. So we agree with the European Union that it's a scope provision rather than exception. The language in Article 3.8a seems to indicate that the scope of national treatment is limited by this provision. In other words, if a measure is covered by Article 3.8a, it will not fall within the scope of Article 3 of the GATT per se as such. So, government procurement. We already mentioned the topic of government procurement when we talked of those agreements which form part of the WTO legal framework. And we discussed the fact that there is a plurilateral government procurement agreement which is not compulsory to all WTO members and which is available to those willing to participate. So the government procurement agreement, the GPA, is indeed the agreement that will provide for national treatment in procurement as between the members. However, for those territories, for those WTO members which are not part of the GPA, government procurement obligations with respect to national treatment are not provided for. You see that Article 3.8a carves out government procurement from national treatment. So that is the field which remains at full regulatory domain of each WTO member, as long as this member doesn't join the GPA. So government procurement measures can be discriminatory. Governments can discriminate in the field of government procurement foreign producers as against domestic producers. You can give preferences only to domestic products. You could say that for the purposes of our state purchases, whatever that be, we will only purchase, say, Russian domestic products if we talk of the government of Russia, or we will only purchase products originating from the EU, or we will only purchase the US products. And it is explicitly carved out from national treatment. So we are not obliged to give foreign products same treatment in the field of government procurement that we have to do as compared to our like domestic products. So Article 3.4 in that sense shall not apply. This is simple. So whenever government develop those rules on purchases, wherever they develop the tendering documentation, the bidding documentation, what we call it in legal English. So whenever we determine the criteria of eligibility for such purchases, governments that didn't join the government procurement agreement, and many did not, Russia did not, China did not, well, as I said, there are only around 40 WTO members, including 27 European Union members and United Kingdom, which was a separate party to it. So 28 already taken up by this huge pool of European countries. So it's mainly for the developed countries. Well, not necessarily. Ukraine, Armenia are also parties to government procurement agreement, but this is something you need to check specifically. So for those countries that did not join the GPA, there is no obligation to treat foreign products in their government procurement no less favorably than the like domestic products. So that is the general rule which will apply here. Now, let me give you an example. I intentionally greatly simplify the picture, and it resembles in a way the situation that happened in the case which is called Canada feed-in tariffs, which I already mentioned a couple of slides ago. Again, the facts were much more complicated and they implied much broader range of legal matters raised. But here, just with this model, I would try to give you the example of those issues that may appear, especially with respect to the regulation of trade in energy, because this system will very similarly reflect in many national mechanisms on the supply of energy, purchase of energy, and on all the government procurement and the government supply of electrical energy to the businesses, to the households located within the territory of this particular WTO member. So let's imagine that we are talking of Canada, and Canada has a province called Ontario Province, and this Ontario Province has a state body which is called Ontario Power Agency. So this power agency is responsible on the one hand on the purchase of generated energy, because it does not, the government itself does not generate energy. Clearly it should be some power plants that will be generating it. They can be state-owned, they can be private-owned, and those public generation companies or private generation companies will then somehow, based on either purchase agreements or on any other forms, depending on the national domain and how it is all regulated domestically, they just pass over all their energy they generated to this Ontario Power Agency, which creates a huge pool of energy generated and then sends it down to the consumers. Because ultimately it's this Ontario Power Agency or its subsidiaries, doesn't really matter here, that is responsible for the maintenance of the supply infrastructure, all those cords, wires, transformators, that takes a lot of resources to maintain and keep in proper shape. So there should be someone responsible for the maintenance of it. Let's assume, for simplicity reasons, it was this Ontario Power Agency involved in this type of responsibilities. And then with the development of alternative energy, renewable energy, the energy of wind, the energy of sun, solar panels, the energy of tide, whatever, there are also some independent producers of this renewable alternative energy, which build up their facilities, windmills, for instance, and they also generate some sort of energy that can be utilized by Ontario Power Agency and further sold for to the domestic wholesale market. So these are those individual, absolutely unrelated to the government, private producers of alternative energy, private alternative energy suppliers. So this group of alternative energy suppliers, they can be rather small enterprises. And again, we put aside the obligation that was developed by the legislation in that particular case, which I mentioned, for those producers to purchase domestic components for those, say, windmills. Let's now take it aside. We are talking now more of government procurement. So government, Ontario Power Agency, also purchases energy from those private alternative energy suppliers. So all in all, they collect all energy generated and then they send it further to the market through the transmission network that is at their disposal, that is their responsibility, and that they pay for the maintenance. So how do they sell this energy? They sell this energy in actually two different markets, let's put it this way. Again, I'm terribly simplifying the facts of the case, and it is very actually similar to what happens in the Russian market. It's more of the Russian market, the way I'm just giving you the example now. It's very similar. So it is sold in two directions, actually. One direction is households. So those are individual consumers. Each of us living in Russia, utilizing electricity that is supplied by any sort of an entity selling us electricity. And there is a second different way of selling electricity in a given in a market. It is selling electricity to businesses. What happens in the market for households and in market for businesses is completely different in sense of pricing of electricity. Why so? Because for households, the government, in pursuit of its social functions, establishes tariffs. So the intention is not to, and here by tariff we don't really mean import tariffs clearly, we mean some domestic maximum levels or some domestic thresholds, or it can be just specifically identified state regulated prices for energy. So there is some process of tariffication, and governments identify what shall be the price of 1 kilowatt of electrical energy per person, per household. It may differ depending on the region, it may differ depending on whatever sort of households we are talking about, but as long as we are not talking of businesses and business enterprises, there are certain limits which are somehow regulated by the government. And the government, in this case, tries to assist its domestic households not to pay excessively for electricity. Again, if prices go high, then domestic population shall get unhappy, and this results in all the negative consequences for any government that will have to sooner or later face the elections, that will sooner or later have to face some other forms of support that will be required from the population. Therefore, governments do not wish to burn oil in this fire of social unhappiness. Therefore, governments try to limit the prices, and very often, in some cases, the prices for the generation and transmission of this electrical energy would not be really covered by those tariffs which the population pays. So that those charges which the population pays will just cover some part of the cost of the production, of the generation and transmission, and the rest may be subsidized by the government. So the prices, let's imagine again, for simplicity reasons, let's imagine that those prices are below cost of production. They are subsidized by the government, and it's the social attempt of the government to perform its social functions. As for businesses, the approach is different. At least it's completely different in Russia, because businesses do not buy electrical energy in the same way. Businesses buy actually not really each and every kilowatt. They buy access to certain volumes, and those access to certain volumes, those volumes are sold in a market, in a usual classical market, which fully depends on the market fluctuations. There can be shortages, for instance, in the production of electricity, or there may be too much of demand in a given market, and then the prices for electricity may go up. So there is no regulation of prices. Market regulates those prices for businesses, and businesses pay as much as the market is ready to propose in a given moment of time. So if you need energy now, then you go and see what is the real market price there. So that is where we start. And the problem here was that those private alternative energy suppliers were concluding agreements with Ontario Power Agency so that to provide their electrical energy to this agency that will further sell it to domestic consumers. So those were the reason of the problem was actually that according to the rules developed by the national legislation here, only domestic producers of energy, of alternative energy, could participate in these contracts, could be parties to these contracts. So following these bidding processes, agreements were concluded only with domestic producers, domestic companies, which were registered in Canada and which were producing energy on the territory of Canada. So who was disappointed? Clearly, the disappointed were the very similar producers of alternative energy, say of the same energy of wind, like product, which were located just across the border, very close to Canada, on the territory of the United States. They were happy to participate in those bidding processes. They would be happy to sell energy to the Ontario Power Agency. Now the question is, under the WTO rules, is Canada obliged to permit, let's now again put aside the government procurement agreement, and again I'm extremely simplifying the facts, even changing them a little just to illustrate our situation that we are now handling. So under the WTO rules, putting aside the government procurement agreement, under the GATT, would Canada, Ontario, be obliged to permit participation of those US producers in those contracts, to participate their access to government purchases by Canada or not? Because the argument of Canada here would be no, we are under no obligation to give you any market access the way we give market access to our domestic producers, purely because of Article 3.8a. We are not obliged to to give you the same treatment that we give to our domestic products, because we are talking of the purchases that were made by our domestic governmental agency for governmental purposes. Now, what I would invite you to think about is to go back to the text of Article 3.8a and try determine your own answer. How would you approach this particular set which I'm laying down? I even invite you to put your video on pause and read the text and try find out your own approach, if you believe it's a violation or if you believe it is perfectly legal under Article 3.8. So what is actually the concern here? The concern here was that this energy that was purchased by the government, and there is no problem with the fact of government purchase here. Indeed, it's a purchase by the governmental agency. But the question here is whether there is some commercial resale that happens once energy enters this big pool of energy of Ontario Power Agency. So if we were able to establish the fact that this energy does not go to the market for businesses, then potentially there would be no violation if we ensure that there is no commercial resale. So there is no resale that permits any profit to be made. So if we talk of this situation as I painted it, here, when energy gets into the big pool of energy by Ontario Power Agency, then from this pool, it is no more colored. You don't really know who gets this energy. Will it be households or will it be businesses? So there is a high chance that this particular energy may be transmitted to businesses, right? And then if businesses buy it, then they will do that at the market price. There will be profit generated. And actually that profit may be used by governments in order to cover the cost of this subsidization of energy prices for the households. So here the situation becomes very complicated purely because of the fact there is no way, at least in my scheme, to ensure that energy from these private alternative energy suppliers does not get elsewhere, but to the households at prices below market price. So if we were to invent this particular mechanism, if we were to demonstrate that energy from private alternative energy suppliers would only get to the households at prices below cost, and it will be only the execution of the social function of the government, there will be no commercial resale, then this situation could potentially be compliant with Article 3.8. However, in my regional situation, there was no way to ensure it. And in that sense, it would be a violation not to permit US producers to participate because there are high risks of commercial resale at the commercial market for businesses. So here again, the text, read it once again. It says procurement by governmental agencies of products purchased for governmental purposes, not with a view to commercial resale, not with a view to use in the production of products, production of goods for commercial resale. So it is extremely important to keep in mind this second half of the sentence, because it's not any purchase by any governmental agency that would fall within the scope of the exemption under Article 3.8a. It is specifically the purchases made for governmental purposes, not with a view to commercial resale or with a view to use in the production of goods for commercial resale. So that is exactly what the appellate body tells us in the decision called Canada Feed and Tariffs. They say that in order to find out if there is a risk of commercial resale or not, if we understand that there can be a commercial resale or not, we need to make a careful assessment of the whole transaction from the seller perspective and from the buyer perspective. So what do they specifically mean? They say that from the seller perspective, we need to check whether the transaction is oriented at generating a profit for the seller. So profit orientation generally is an indication that a resale is at arm's length. So the resale is commercial. Profit orientation indicates that the seller is acting in a self-interested manner. However, they do not say that it is only and necessarily this profit that shall be generated. There can be different situations and there can be different circumstances in which a seller may offer a product at a price that does not allow him or her to make a profit, or sometimes even fully recoup the costs. Yes, they're mindful of these situations, but this is not what our situation was. In such circumstances, it may be useful to look at the seller's long-term strategy, and maybe there is some reason why ultimately it will be still a commercial resale in the long run. But then, apart from that, we need to make sure that we assess the transaction from the perspective of the buyer. Because when we talk of a buyer, then we need to make sure that the buyer also in this situation actually intends to maximize his own interest. The buyer seeks to maximize his own interest. So the buyer is also trying to get benefit out of it. So if we look at the transaction from these both sides and we see that both parties are acting in their interests, both parties are trying to maximize their own benefits, then we have a situation of a commercial resale. In my example, which I gave you, clearly there was a very high risk of commercial resale of this energy. It was purchased with a view to commercial resale. So without any additional safeguards of non-commercial resale, purely non-commercial resale, Article 3.8a would not be available to the situation I portrayed. There was one more interesting situation, which was actually one of the very first disputes at all considered in the GATT times. Well, at least this was one of the first to tackle questions of non-discrimination. It's an extremely funny, from the modern perspective, extremely funny GATT panel report. It's only 3 or 4 pages long. Unlike modern hundreds pages long panel reports, here what the matter was about is the Belgian legislation, which was in place in 1952 when the case was considered by the GATT, the forerunner of the WTO. What happened was that Belgium actually introduced a levy of 7.5% on foreign products which were purchased by public bodies purely for governmental purposes, so no risks of commercial resale and no implication of commercial resale even anticipated. However, what was the reason of this payment? What happened with this payment? The problem with this payment was that Belgium actually wanted to charge more products, to introduce an additional charge on products which originated in countries whose system of family allowances, social security, did not meet specific requirements. What is meant by this phrase? So in Belgium, there was a system of certain guarantees for family allowances for social security. And in particularly, the directors of undertakings were required to pay contributions for the purposes of providing family allowance benefits to their employees. What ultimately results in higher prices for domestic producers to produce products, and they incorporate those additional payments clearly in prices, and prices goes up. So we understand the logics of Belgium. They want to level the playing field. If our domestic producers have to pay more for family allowances, for social security, let's try to somehow balance it through this additional levy. But again, it is not entirely a border tax adjustment. It is not a charge on whatever additional, not a charge on a product, not a charge on the article from which it has been manufactured in whole or in part. So the Belgian family allowances case was with respect to actually Article 3.8, because again, bear in mind, it's a question of government procurement. So government procurement and only government procurement was involved here. If the government purchases the product, would you wish to supply this product? If your product originates from the territory with lower social charges, then before your contract actually gets enacted, before you could supply these products for governmental purposes in Belgium, you would have to pay this additional charge of 7.5% of the value of the product. So in some European countries, for instance, the Netherlands, Sweden, France, the domestic system of family allowances was considered meeting the requirements, and therefore products originating in those territories were not charged additionally, whereas in Norway and Denmark, domestic systems of social security in that sense were not considered adequate, and therefore additional charges were introduced on those products originating from Norway and Denmark, who were actually the complainants in 1952 case. So they were unhappy with the fact that their products are subject to this additional charge, making them actually in the long run less competitive. So getting distant from the real facts, our goal is to understand the fundamental problem. So if we talk of Article 3.8, does it permit additional charges to be levied on procurement from certain countries, from certain origins? And apart from all the other MFN implications that could be here, there was one more matter that actually attracted the attention of the GATT panel in this particular case. And in order to see it, let's once again focus on the text of Article 3.8a. It says, the provisions of this article shall not apply to laws, regulations, or requirements governing the procurement by governmental agencies of products purchased for governmental purposes, not with a view to commercial resale or with a view to the use in the production of goods for commercial resale. So here, do we have the situation of procurement by governmental agencies? Yes, it was fully falling under this category. Products purchased for governmental purposes? Yes. Not with a view to commercial resale? No, not with a view to commercial resale. Not with a view to use in the production of goods for commercial resale? No, not with a view to the use of goods, to use it in the production of goods for commercial resale. So here the situation seemingly falls within the ambit of Article 3.8a. And Belgium had a feeling it has a strong case to justify such measures under Article 3.8a. However, what is the tricky thing here? Let's once again read it. It says, let's just go to the text and read what the Belgium Family Allowances panel report said actually, and we may return to the text. The panel did not feel that the provisions of paragraph 8a of Article 3 were applicable in this case, as the text of the paragraph referred only to laws, regulations, and requirements, and not to internal taxes or charges. Let's return to the text. The provisions of this article shall not apply to laws, regulations, requirements. Now let's recollect what we discussed in Article 3, 3.2 and 3.4. You remember that Article 3.2 deals specifically and exclusively with fiscal measures, with taxes, charges, payments, so price-based mechanisms. Article 3.4, if you recall, uses exactly the same phrase, laws, regulations, and requirements. Laws, regulations, or requirements, therefore, here in Article 3.8, for whatever reason, are mentioned. Whereas in other provisions, you can check, say, Article 3.1. You will see that whenever the whole scope was intended, then in 3.1, for instance, the drafters would mention both internal taxes and laws, regulations, requirements affecting sale, offering for sale, distribution, transportation, use, whatever. So here, for whatever reason, the drafters of the GATT omitted these words, internal taxation. In the provision of Article 3.8a, there is no reference to internal taxes. It only says shall not apply to laws, regulations, and requirements. So the position of the panel here is that this omission cannot be interpreted as just accidental. This omission necessarily should have some meaning. And those drafters who were drafting the very same Article 3 understood there is this dichotomy, there is this big difference between the two pillars of regulation, taxation and administrative measures. And for whatever reason here in Article 3.8a, they only refer to laws, regulations, or requirements. And that is the reason for the conclusion that the panel arrives at. Let's read it once again. The panel does not feel that the provisions of Article paragraph 8a were applicable in this case, as the text of paragraph referred only to laws, regulations, and requirements, and not to internal taxes or charges. As long as we were talking of a levy, we were talking of a tax, of a charge, it was under Article 3.2 and not 3.4 if we would qualify it within these two categories, then according to the GATT panel report and Belgian family allowances, it is not covered by the exception. So it is an interesting situation that on the one hand, you can discriminate foreigners in a view of this report. You can discriminate foreigners, but you can only do it through regulatory measures. When we talk of government procurement, you could not discriminate the foreign products through taxes, through charges. You have to apply administrative rules in a discriminatory fashion, and you cannot, as if you cannot apply taxes, charges, payments. So according to this position of the panel report, it's only regulatory restrictions that are permitted under 3.8a and not taxes, charges, and levies. This provision has been criticized, and you may sometimes even read that it was an omission, it was even a mistake, let's say, of the panel, that the panel misinterpreted the provision, the panel misread the content of it. However, that is what is there, and that is the approach that has been expressed. So when developing domestic mechanisms of restricting access of foreigners to procurement, still governments should be mindful of this position. So when determining the ways to discriminate a foreigner, it's much safer under the provisions of Article 3.8a to follow regulatory mechanisms and not to implement price-based mechanisms, payments, taxes, charges, because they may be found to be outside the scope of Article 3.8a because of the text, because of the way the provision is drafted. So this is as for 3.8a, rather simple. Just these two things to keep in mind: regulatory measures and regulatory measures and taxation measures, and the purchases not with a view to commercial resale, purchases by governmental agencies for governmental purposes. All these elements are cumulative, so you need to complete all of those requirements in order to qualify for the exemption. Then there is the second part of the provision, which deals with subsidies. And we already recall that it permits some discrimination of foreign producers in the field of subsidization. The provisions of this article shall not prevent the payment of subsidies exclusively to domestic producers, including payments to domestic producers derived from the proceeds of internal taxes or charges applied consistently with the provisions of this article, and subsidies effected through governmental purchases of domestic products. So as we said, most importantly, the essence of the obligation, the real content of it, is before the comma. The provisions of this article shall not prevent the payment of subsidies exclusively to domestic producers. We understand the political reasons behind it. All governments in the world subsidize their producers. There is no government known to me that completely got rid of subsidies, and some of the producers in some regions are still alive purely because of subsidies. If you see how tremendous subsidies to European farmers are, you would be perplexed at knowing those figures. You don't even imagine how big those figures can be. And unlike Russia, for instance, which has under the WTO rules a lot of more space for possible subsidization of the agricultural sector, EU exhausts all the possible permissible subsidies to producers of agricultural products. So here we understand that every government wishes to give subsidies only to its domestic industries. We don't want to subsidize foreigners, and therefore politically we understand the reasons behind this provision. We understand that the drafters did not want to permit the subsidization of foreign products, and therefore there was no better way to negotiate the agreement. Well, we could either completely not reach any conclusion and any agreement, or we could carve out subsidies to domestic producers from the national treatment obligation. So if we would read the general assessment of this provision by one of the panels in EC large civil aircraft case, I mentioned this case in one of the earlier lectures when we talked of subsidies. It's a Boeing Airbus dispute. So here EC was the respondent, so it's complainants by the US against subsidies to Airbus. In effect, Article 3.8b confirms that, without more, the mere payment of subsidies to firms so long as they engage in domestic production activities should not be interpreted as impairing to such subsidies a discriminatory element, as imparting to such subsidies a discriminatory element, as among domestic and foreign goods in a manner that Article 3 may discipline. Indeed, if this were not the case, then it appears that the only way for a WTO member to avoid a payment of subsidies being prohibited under WTO law would be to offer the subsidy payments to firms worldwide. As long as we all understand governments are not ready to offer subsidy payments to firms worldwide, they introduced this provision. So just the fact of paying the subsidy to domestic producers is permitted. However, here mind the fact that there is one more agreement that came into existence in 1995 with the advent of the WTO, and that is the agreement called SCM, Agreement on Subsidies and Countervailing Measures. Article 3.8 does not exclude the application of the SCM, and the enactment of the SCM does not somehow impact the existence and functioning of Article 3.8b. So here, keep in mind that there are certain subsidies, meaning specifically import substitution subsidies and export subsidies. I think we mentioned it, but still it's not the major topic of our conversation in this course. So under this agreement, there are certain prohibited subsidies. Within the ambit of the GATT, you would not see disciplines of this type as strict and as specific as the SCM agreement. So the SCM agreement does introduce restrictions on subsidies even to domestic producers, and it will not be permitted to pay subsidies which which will be dependent on export performance, which will be contingent on export performance, nor will it be permissible to introduce subsidies that will be dependent on import substitution, on the use of domestic over imported goods. But this is not what we are interested in now. Now we try to understand what is permitted, and payments to domestic producers which are not otherwise prohibited by the SCM agreement shall be possible. They are permitted, they are allowed. And Article 3.8 remains fully in force despite the fact of the existence of the SCM agreement. So what are the forms of those possible subsidies? Because, well, when we think of subsidies, in most jurisdictions, we treat subsidies as some direct transfer of funds from the government, state grants, as we can call them. But it's not only what international law understands under the term subsidies. Subsidies are interpreted much broader, and they would include not only, say, direct payments, they would include tax breaks, tax exemptions, when the government does not collect their revenue that is otherwise due. So they forgive you the payment of taxes. They permit you not to pay. What is it? It is a subsidy in a form of, well, if it's a measure that gives a benefit to a certain enterprise in a given market, then clearly, then it is a subsidy. And WTO rules treat it as subsidy as well under the SCM agreement. Would such subsidies also be permissible? Or when we read Article 3.8b, do we necessarily mean direct transfers of payments? That is an interesting interpretation matter, because in the times of 1947, we did not yet have those detailed rules on subsidies that we now have in the SCM agreement. Article 1, the definition of subsidy was lacking. Therefore, such benefits in a market not available to the other market players could well be considered as incompatible with Article 3.8b, or on the contrary, we could consider that governments are permitted to give subsidies not only in the form of a direct transfer of funds, but also in other forms available. Here is the reading that was adopted by the panel in Brazil taxation case. An examination of the text and the context of Article 38b, as supported by its negotiation history, suggests that the term payment of subsidies, it says payment of subsidies. Keep in mind this word payment. It makes a huge difference as compared to provision of a subsidy, granting a subsidy. Payment of subsidies in Article 38b does not include within its scope the exemption or reduction of internal taxes applied directly or indirectly on domestic products. Instead, as the appellate body has observed, Article 38b was intended to exempt from the obligations of Article 3 only payment of subsidies which involves the expenditure of revenue by the government. So there is one important caveat when we talk of such subsidies. It is important to understand that these subsidies will only work as long as we talk of expenditures of revenue by government. Once we find any other forms of subsidies, when government supports businesses but doesn't really pay, the financial contribution takes a different form, not implying the expenditure by the government, then we do not qualify for Article 38b. So this is it. Then there has been a number of cases when those subsidies that were aimed at supporting the producers, domestic producers, were not paid directly to the producers, but they were paid to the consumers. The reasons are also clear, because whenever you give money to consumers, they are very happy. On the one hand, they see direct support by the government and it increases political capital of the government. Secondly, you safeguard from some bad faith on the side of the producer, because producers may get the subsidy from the government, but they may not decrease the price for the product. And here, giving a subsidy to a third player would, on the one hand, increase the benefit for this player to purchase domestic products, and on the other hand, it will still support the domestic product. So can we say, if you purchase a Russian tractor, you can then come to the Russian Ministry of, I don't know, Industry and Trade, the Russian Ministry of Agriculture, and then from the cash office, you get 10% back, cash back, but operated by the government, but only applicable to the domestic product. Only if you buy Russian tractors, you are eligible for this cashback. And there has been a number of cases where this matter actually raised. One of the first cases was the case with respect to Italy and its agricultural machinery support program. So under the Italian law, special credit facilities were provided to farmers who wanted to buy Italian agricultural machinery. So again, it's not the producer who gets the direct benefit, the direct funding, preferable terms of credits. However, it's the domestic consumer. Still, who wins, who benefits from this system? Clearly, domestic producer. Because if you could purchase a foreign tractor at a more expensive credit, or a domestic-like tractor, which is, say, functionally suits you, if you can buy it at a lower credit line, at a lower credit interest rate, which one would you choose? You will most likely go for the domestic one, again, if it's fully compatible with your needs. So ultimately, the goal was to support the domestic market, the domestic producer. Then the other case, the famous case of oil seeds and animal feed proteins. And there the European Economic Communities in that times, 1990, not yet even EC. So the European Economic Communities legislation provided for the payment of subsidies to the processors of oil seeds. And they will give those subsidies only in cases those processors demonstrate that there is domestic oil seeds that has been actually obtained and processed. So it's domestic producers who get the benefit. It's the domestic producers who get actually the advantage because of this measure. However, monies don't go to directly to domestic producers. They go to domestic producers. The economic benefit goes to the consumer, to the producers through the consumers, through the processors. So the question here was whether it is compatible with the provision of Article 3.8b or not. And if you recall the provision, it says that this article shall not prevent the payment of subsidies exclusively to domestic producers. So this provision has been interpreted very narrowly, and this word exclusively is not standing there in vain. It has a meaning. And therefore, say GATT panel report in oilseeds, proteins, it says Article 3.8b applies only to payments made exclusively to domestic producers, and considered that it can reasonably be assumed the panel considered that it can reasonably be assumed that the payment not made directly to producers is not made exclusively to them. The economic benefits generated by the payments can at least partly be retained by the processors. And as long as this economic benefit can at least partly remain with the consumer, with the processor, the payments generate a benefit conditional upon the purchase of oilseeds of domestic origin, inconsistently with Article 3.4. So here they say that it will go contrary to Article 3.4 because you are actually forming some artificial demand for the product through this mechanism, and it goes contrary to Article 3.4. It's not exclusively to domestic producers. You are distorting the market conditions contrary to Article 3.4. Under these circumstances, Article 3.8 would not be applicable because in that case, the payments would not be made exclusively to domestic producers, but to processors as well, as processors can at least partly retain some of the economic benefit. So this is important to bear in mind. Those subsidies shall necessarily be directly to domestic producers and not otherwise. Therefore, in many regulations of WTO members that establish the framework of subsidies, you will see the reference to the payment directly to producers. That is important because businesses very often wish to structure subsidies differently. Again, domestic public is not always happy to see big chunks of money going to big corporations. Governments would be pleased to involve consumers or to involve some processors, downstream industries. They would love to have someone otherwise involved so that not to make the feeling that government excessively supports big businesses. Therefore, here, what is required is that payments are made directly to domestic producers and not to domestic consumers, to domestic distributors, not to domestic whoever else, processors, whatever. And then secondly, we need to ensure that those subsidies involve government expenditures, that those subsidies necessarily imply government payment and not just reduction of taxes, tax breaks, forgiving some other government revenue that was otherwise due. So under Article 3.8b, for these exceptions to be permitted, such subsidies shall be on the one hand direct, and on the other hand, they shall imply the payment of funds from the budget. And there was one more tricky case, which I would like to talk to you about. It's one of the most fundamental cases, actually. I love it very much of all the cases which we mentioned, and I very often use this case in various exam questions because it demonstrates the understanding of all the functioning of the mechanism of the GATT, of different provisions, how they interplay and how they interact. You would not recall the situation already, but in 1990s, EC and South Korea had very serious tensions, trade tensions, if not trade war, but clearly tensions. And there has been a number of very questionable trade measures imposed as against each other. And one of the fields of this hard competition and aggressive trade policies against each other was the trade in commercial vessels. So those could be, that is the example of a commercial vessel, so that you understood what we are talking about. But it's not only container ships, there were different types of other ships that were at stake in this particular dispute. And this dispute opened up an interesting question of the interplay between various WTO provisions. So it was about subsidies. What was actually the concept of this case? In EC, they developed a temporary defensive mechanism for shipbuilding. As you see, it was a council regulation in 2002. It was further amended, but in the long run, what was the idea of this EC rules? Because there was a feeling that Korean enterprises are involved in some unfair trade practices, therefore, the European Union wanted to develop a mechanism, the European communities wanted to develop a mechanism so that to specifically hit Koreans. They provided for a mechanism with direct aid, so subsidies, state aid. It's the European euphemism for subsidies, actually. State aid in support of contracts for the building of container ships, product and chemical tankers, as well as liquefied natural gas carriers. And this direct aid would be provided when there has been competition for the contract from a Korean shipbuilding yard offering a lower price. So now, and these schemes were implemented by Denmark, by France, by Germany, the Netherlands, and Spain. So many of the EC members used it. So let's get back to this vessel. You understand that vessels are not also provided just in case someone comes and buys a vessel. How would a vessel be purchased? If there is a big shipping company that wishes to purchase a vessel, it announces a tender. It will not be a question of government procurement. Clearly, government procurement has nothing to do with this part of the story. We are now talking of vessels which are purchased by commercial entities. So a commercial entity that wishes to buy a vessel announces a competition. And then several shipbuilding yards from all parts of the world could participate. And whoever gives the better price wins the tender. The situation is simple. So clearly, only once the tender is won, the shipbuilding starts actually. So no one constructs a ship to keep it because it is costly, it makes little sense, and again, who would buy a ship not specifically tailored for the needs? So whenever there is a competition, according to these rules, whenever there is a competition for this future contract, for this contract to construct a would-be ship, whenever there is a competition, and if the European producers manage to demonstrate to the authorities that they are competing in that for that contract with the Korean shipbuilding yard that is offering a lower price, then there is a system of subsidies, and then the European producers can decrease the price and win the contract. So that is the system. If they are fighting in a competition against Brazilian shipbuilders, Indian shipbuilders, Russian shipbuilders, US shipbuilders, or Canadian shipbuilders, or Australian shipbuilders, no state support will be provided, no subsidies will be given. So what are those subsidies? They are direct transfers of funds, pure subsidies paid from the budget directly to the producers without any intermediaries. And the only criteria for eligibility, well, for simplicity reasons for our purposes, was this competition element against Koreans. So if you manage to demonstrate that you are against Koreans, you can get the money. If you are against Indians, Russians, Brazilians, you do not get the money. Now try to make your own assessment with reference to Article 3.8b Would this be compatible with Article 3.8b, and do you see any other problems with this scheme? Again, please put the video on hold, put the video on pause, make your own assessment, because again, it will be the type of questions you may face during the exam. So, you've seen the text of Article 3.8b. The provisions of this article shall not prevent the payment of subsidies exclusively to domestic producers. Seemingly, we fit all these elements, right? It's subsidies exclusively to domestic producers directly without any intermediaries. And indeed, there is no violation of Article 3.8b. That is exactly what the panel arrives at. However, what is the problem that we feel? The problem, what is this discriminatory smell coming out of this picture? The discriminatory smell is that we discriminate products based on their origin, but we are not discriminating a domestic product against a foreign product in this case. We feel that there is some discrimination between foreign products because Korean products are discriminated against in the eligibility criteria of the subsidies as compared to China's products, Russia's products, Brazil's products, whoever else's products. So we may have the feeling that there is an element of discrimination between foreign products based on their origin, right? It is not a question, so when we have two foreign products discriminate against each other, it is not a question of a national treatment provision, right? It's the requirements that were discussed and that were enshrined in the provision of Article 1 MFN. So this is exactly MFN provision, which is potentially violated. Is there an Article 1 violation or not? You remember the text of Article 1. Let's get back to this text. Long, but again, I am just bringing you back to this very same slide that we were reading. We are saying that any advantage, favor, privilege, or immunity granted by one WTO member to any product shall be immediately and unconditionally provided, granted, accorded to the like product originating in all other WTO members. So what happens here is that we do give a certain benefit to all members but Korea. And this is the benefit in a way that they are not discriminated against in the field of subsidization. However, what is tricky is whether actually this provision covers this type of measures we are talking. So let's get back to the first half of the provision, and you see here I already highlighted the most important words. So what is the scope of obligation in Article 1? What does it apply to? Does it apply to everything? No, it has a certain limited scope. In order to understand if Article 1 is violated here or not, because Article 3 is not likely to be violated because of the exemption under 3.8b. So we need to find out if Article 1 permits this type of subsidies. Is it at all covering this type of measures? So what does it address? It addresses customs duties, charges of any kind. Is it our case? No. Charges in connection with importation or in connection with importation. Our case? No. It is not a charge in connection with importation, it's a subsidy. Is it a charge on international transfer of payments? No. Is it a method of levying duties and charges? Again, not. Is it with respect to all rules and formalities in connection with importation and exportation? No, clearly not. It's not at all a question of importation and exportation. It's a question of subsidies to domestic producers if they compete against a particular product of a particular foreign origin. And with respect to all matters referred to in paragraphs 2 and 4 of Article 3. When we were reading this provision in our MFN lecture, I intentionally didn't mention a word about this part of the text. So I understood we will get back to it because at that moment in time, it would be difficult for you to understand what it actually means. Because at that moment in time, you did not yet know what is meant by paragraphs 2 and 4 of Article 3. So now you understand what it is. It's domestic taxation and domestic regulatory measures which affect sale, offering for sale, distribution, transportation, use of a product. So having read that, we now understand that MFN, the general MFN rule, does not only apply to measures related to crossing the border, to border measures, to customs duties, taxes, charges, international transfer of payments, formalities in connection with importation and exportation. No, Article 1 is much broader in scope. Article 1 also applies to all matters referred to in paragraphs 2 and 4 of Article 3. So it applies to domestic taxation and it applies to domestic regulatory measures. So if we would introduce a different system of taxation that will discriminate between foreign products based on their origin, like products based on their origin. Say we do not have any domestic product and we do not see this discrimination as amongst the domestic and foreign product. We only have this discrimination as against two foreign products. So we introduce a tax, say, on a higher tax on Gruyere cheese, as opposed to all other hard cheeses. Gruyere cheese is a cheese that is produced only in Switzerland. Well, at least I hope so. At least unlikely anyone else produces a proper genuine Gruyere cheese. So if we say that Gruyere cheese is subject to a much higher tax than all other like foreign hard cheeses, will it be a violation of Article 3? No, it will not be a violation of Article 3 if there is no discrimination as against the like domestic product. We could say that all domestic cheeses are taxed even 10 times higher than foreign cheeses. It can be the case. However, the violation will here be not of Article 3, but of Article 1 and of MFN, because MFN prohibits discrimination in the field of internal taxation based on origin of products, on foreign origin products. So you cannot give a more preferable, not a more preferable tariff rate to, sorry, again, not a more preferable tax rate, domestic tax, internal tax rate to the foreign product from, say, Italy, and not give the very same treatment, at least to give the same advantage to the like product originating in Switzerland. Same applies to domestic regulatory measures under Article 3.4. So we could not introduce the discrimination in the field of regulatory measures because we will go contrary to Article 1 if we start discriminating foreign products based on their origin. If we say, I don't know, German cars could be sold in any of the distribution centers in Russia, whereas China's cars or US cars could only be sold in 5 distribution centers in the most distant parts of the countries. Could that be developed? Well, potentially such kind of regulation could happen, and it will not go contrary to Article 3.4 because there can be no modification of conditions of competition to the detriment of the imported product as compared to the like domestic product. There may be this violation as well, but it may be not present. However, if we give a preference to one foreign product and not give it to the other foreign product, we violate MFN. And MFN does not only apply to articles, to matters of crossing the border, to customs duties, methods of levying such duties, but it also applies to those internal measures in Article 3.2 and 3.4, internal taxation and internal regulation. Now comes the major question. Does this mean that subsidies which are provided for under Article 3.8 are also covered by MFN? So would the European Commission be permitted to maintain the scheme. Would these domestic state aid programs, national state aid programs, be permissible or not under Article 1? Because here we see that there is a reference to Article 3, paragraphs 2 and 4. We do not really see here any reference to Article 3 as a whole. We do not see any reference here to Article 3.8. So we need to understand, in order to answer this question, whether EC can keep those subsidies or whether EC needs to remove those subsidies as soon as possible. We need to understand how to interpret the text of this Article 1. In particular, this phrase, with respect to all matters referred to in paragraphs 2 and 4. Is payment of subsidies to domestic producers matter referred to in paragraphs 2 and 4? That is the question for the interpretation. And depending on how we interpret it, depending on what conclusion we arrive at, we may have opposite solution of the particular matter. EC may either keep the subsidies or EC will have to remove the subsidies. So once again, to make sure we all understood it, the concern here is whether it also applies, whether MFN obligations also apply to matters referred to in paragraph 8 of Article 3. That paragraph is not, for whatever reason, mentioned in the text of Article 1. So what does EC vessels panel arrive at? Actually, this decision has never been challenged to the appellate body, so it remains the position of the panel. We don't know if the appellate body would support it or not. But what the panel here says is that this regulation is a measure that fully falls within the scope of Article 3.8b, as we said, because it provides for the payment of subsidies exclusively to domestic producers, and therefore they do not see it to be inconsistent with Article 3.4, again, because Article 3.4 simply does not apply to this type of measures. And the question here is whether, and if so, how, Article 3.8b affects the scope of all matters referred to in paragraphs 2 and 4 of Article 3. And actually, that is a big fundamental discussion on the understanding of the part of this provision in the context of Article 3. Because one of the arguments that could be made is that Article 3.8 is the exception from Article 3.2 and 3.4. And if it was the exception, it may be implied to be linked to Articles 3.2 and 4. And therefore, with reference to 3.2 and 3.4, we also make reference to 3.8 in the text of Article 1. There can be an alternative approach. We could say, no, Article 3.8 is not the exception from Articles 3.2 and 3.4. It's the exception from the whole Article 3, or the exemption from the whole Article 3. And maybe even this fact of exemption would also matter. But say it's the exemption from the whole provision of Article 3. And without making reference to Article 3 as a whole, the drafters of Article 1 did not intend to include Article 3.8 in the scope of MFN obligation. And ultimately, depending on how we respond to this question, we either need to remove a huge program of subsidies, or we could be permitted to keep it. Let's see what the conclusion was. I could not say it better than the panel in this paragraph, so let's just read it what they wrote. If it is explicitly provided that a particular measure is not subject to the obligations of Article 3, as we know it is the case in Article 3.8, that measure, in our view, does not form part of the matters referred to in Article 3.2 and 4. Since 3.8b provides that Article 3 shall not prevent the subsidies paid exclusively to domestic producers, such subsidies are not part of the subject matter of Article 3.4 and cannot be covered by the expression matters referred to in paragraphs 2 and 4 of Article 3 in Article 1.1. So what is the conclusion out of that? As long as it is the exemption from the whole Article 3, it is not even potentially implied to have been mentioned in Article 1.1. Therefore, MFN does not apply, even though it is an extremely fundamental obligation, extremely fundamental. And we know that MFN is the underlying principle of all international trading system, but it also has its limits. So reading the text as it has been drafted, and this is exactly what lawyers do, and this is exactly the type of work lawyers need to be skilled at, reading the text of the provisions based on what has been inscribed in each and every word. So reading this provision, we understand that this reference to 3.2 and 3.4 could not be implied to refer to 3.8. And even though one could say, well, still 3.4 talks of subsidies as well, so it's a regulatory measure that introduces a subsidy. Yes, in a way, that subsidies that are provided to the domestic producers are completely carved out from the regulation under Article 3.4, and they are not subject to 3.4 disciplines. Therefore, as long as they are not within the ambit of 3.4, they could not be considered as matters referred to in 3.4. There is some criticism that has been posted against this decision, and this criticism states that it is fundamentally wrong to have said that, as far as the panel limits the scope of the application of the MFN regime, which again is fundamental. However, reading the text as it is written, seemingly that would be the most reasonable conclusion a good faith interpreter could arrive at. So keep in mind that MFN, though being a fundamentally important obligation, has its limits. It does apply to border measures, it does apply to internal measures, to taxation, to regulatory measures. However, MFN does not apply to matters provided for in 3.8, because those are not subject to 3.2 and 3.4. They have been carved out, and therefore they were not matters referred to in those provisions. So MFN is not endless. Whenever you want to apply MFN, take a minute, get back to the introductory part of the MFN in Article 1.1 and make sure that your particular matter falls within the scope of this article, because not, as it turns out, not everything that we may even emotionally feel as discriminatory would actually violate MFN. That is it, that is important. So be specific, be precise, and always check the text. That is the underlying conclusion of the story, EC vessels. So answering the question, does this text in Article 1.1 cover Article 3.8? Our answer is no. MFN does not apply to subsidies provided for under 3.8b. So the European Commission was permitted to keep this regulation. Domestic schemes of subsidization were permitted to be maintained, even though we all feel that smells discriminatory. We feel it doesn't smell well because we discriminate a product based on its origin, but again, MFN has its limits. As any provision, whenever you want to apply it, go and check the scope of obligation before you go to the substance of the application. And there is one more case I wanted to tell you before we conclude, because it also demonstrates an interesting interplay between various provisions of the WTO treaties, of the WTO treaty, in our case of the GATT, and it was a case called China Autoparts. So China Autoparts case is a very good way to summarize what we have already discussed. Because it implies the interplay between the fundamental principles that we were talking about and the border measures regulations that we have covered before in our prior lectures. So what was the case behind the story? When China acceded to the WTO, as we already know China necessarily had to make its schedule of concessions. And under this schedule of concessions, China would have two different tariff bindings with respect to two different types of products. I simplify it again as maximum as possible, just to avoid unnecessary details. But the idea was as follows. For auto parts, for the components, if you introduce components to the territory of China, for them to be used as components, you pay a customs duty of 10%. If you introduce a complete vehicle in the territory of China, you would have to pay a higher duty. It would be 25% and not 10. We also understand the reasons behind this type of reasoning. All countries wish to have the maximum value added on their territory because it gives employment, it creates workplaces. So clearly, everyone wants to introduce components, and everyone wants to protect from introduction into your customs territory of complete vehicles. So if you would bring a finished car, then you would pay 25%. If you would bring parts and components, you would pay 10%. What China actually did, in addition to that, is that they introduced some anti-circumvention regulation. They introduced some mechanism in order to avoid playing around and in order to avoid violations, in order to secure that these tariff bindings are respected. How did it work? So China said that they will apply these duties to parts and to complete vehicles, but they would introduce a different definition of a complete vehicle, actually a specific definition of a complete vehicle. It's not only the finished car itself with all details necessarily, with each and every minor button and nail already in it, but they said that they understand complete vehicles to be actually those vehicles to be actually those components which are really introduced for the purposes of assembling in a final finished product. So if you import the so-called CKD or SKD, those are knockdown or semi-knockdown kits for assembly purposes, that implies you are going to assemble them in a car. There is even such a phrase, at least we clearly use it in Russia when we talk of automotive producer. I guess it is also used in English, though I never heard, like a screwdriver assembly. When these components, these kits are so big, when all the complex work has already been done, welding, painting, a lot of things have already been actually performed, and then you just introduce components that can be connected so simply, so straightforwardly, without any significant work to be performed, so that it is called literally a screwdriver assembly. So you just have a screwdriver and then you have it assembled. So as if each of us could do that at home. Clearly, it is excessively simplistic, but actually, that is something like this SKD that you can see now on the screen. So it's a whole bunch of all details that are packed as one package and then imported to China. So China says, guys, we understand that you are actually trying to introduce a finished car and not components. You are trying to go around the customs duty. You are playing the tricks. You are circumventing. So if you are introducing this type of kits, then we will charge you as if you introduced a finished car, 25%, because your real intention is not to introduce components, to introduce auto parts. Your real intention is to introduce a finished car. As long as you are introducing a finished car in our territory, please pay 25% duty, which will be correct. That is what we promised to you when we entered the WTO. Then what are the other things? Well, the imports of some major components in certain combination would also qualify for the complete car. Clearly the engine, some of the other major crucial elements, and then imports which would actually in price be totaling to 60% and more of the total price of a complete vehicle, would also be considered by China to be matters of complete vehicle importation. So what happens actually? If you introduce those elements, if you introduce those components, and then you assemble those in the finished car, you will be charged an additional payment of 15%. So if you just introduce those elements and then you use components without the intention to assemble it in a finished car, then you just pay 10%. But if you introduce this as if finished car, as if final complete vehicle, then the China's authorities will be keeping an eye on what you are doing, and they will make sure what happens with those components. If that was triggered by one of those rules that we just mentioned, SKD, CKD, value of imports, and if they are converted into a vehicle on the territory of China without really adding much of details of the local market, then you will be subject to this additional payment of 15%. So this additional payment is just the difference between the customs duty you had to pay at the moment of importation if you would have been fair and if you have identified your real intention. Your real intention was to introduce the finished product, for the finished product to be present in the China's market. Whereas you did not do that, you introduced components, you were trying to circumvent, go around the duties. So now if you assembled it in a finished product, we make you pay additional 15%. So how does China classify this payment? China says it is fully in compliance with my WTO obligations. Why so? Because it is under Article 2, under the schedules. I promised 10% for components and 25% for the finished product. And if you are if you are importing components and they are used as components, if your intention is focused on components and then they are sold and used for whatever other purposes, then no additional charges are paid. If we make sure that you assembled it in a final car, in a complete vehicle, then you are just circumventing the customs duty and you are asked to pay additional 15%. So that is the classification of China. They understand that this measure is to be treated under Article 2 schedules. They don't go above the permitted levels. They are fully in compliance with their obligations. That's the position of China. What is the position of the complaining party, EC, in this case? EC says, no, this is not a question of a tariff. This is not a question of crossing the border, and this is not a question of schedules. What we deal with here is an additional payment, a tax, if you wish, that is only imposed on foreign autoparts and is not imposed on the like domestic products. So they look at this situation from the perspective of Article 3 of the GATT. They say, guys, we are not really now talking of anything that happens at the border. The question is that you are taxing us additionally. Your domestic components, when being assembled into a finished car, are not subject to this additional payment of 15% of the value of the car. So as long as your domestic products don't pay it, you cannot make foreign auto parts like products. So under Article 3.2, they cannot be taxed in excess. And this is excessive taxation. You taxed us in excess of the like domestic components. And therefore, depending on how we qualify this payment, whether it's a matter of schedules and it's a customs duty, or whether it's an internal tax, we will arrive to opposite conclusions. There will be either a violation on the side of China or there will be no violation on the side of China. And in order to understand that, we need to then determine whether it is a matter that is a charge in connection with importation, as Article 2 says, or whether it's an internal tax. Is it under Article 2 or under Article 3 that we need to qualify this payment? Is it a border measure or is it an internal measure if I would use the terms of international trade law? And it is essential to understand this difference, because unless you understand what is the nature of the measure, you do not really know which rules shall apply. Because with respect to border measures, Article 2 will be applicable and schedules. And with respect to internal measures, Article 3 will apply. And you see that they bring us to opposite conclusions. So what is the principle that has been developed by the appellate body in this China Autoparts case? They were trying to make this borderline between border measures and internal measures. And the underlying principle here is what triggers the obligation to pay. In order to make this qualification, you need to understand what is the event that triggers the payment. If it's the question of crossing the border, it will be the border measure. If it's the importation that we pay for, if it's some internal event that actually triggers the payment, then it is already an internal measure. So why do we say that domestic income taxes are internal measures? Because they tax income that happens within our territory. Or if we talk of some income on foreign Russian, at least Russian citizens. It's again the fact of citizenship and the income of a citizen of Russia that triggers the payment. So there is this domestic event, internal event that triggers the payment. Therefore, it is not a border measure. What was the obligation to pay triggered by in this case? The obligation to pay was triggered because of an internal factor. That's what the appellate body says. Because the product was either further resold internally or because it was used internally for the assembly. So it's the assembly of the product of the parts in the finished car that triggers the payment. It's not the fact of crossing the border. It's the domestic event of the assembly that actually initiates the payment, that triggers the payment. In the sense that such internal factor occurs after the importation of the product of one member into the territory of another member. So here the appellate body clearly says that in order to understand the nature of the payment, we need to find out what is underlying it. So it is not the fact of importation that matters, or it is not the moment when the product pays that matters. Important is the reason for this payment. Important is the ground for this payment. Important is the triggering event of this payment. So here we talk of the internal factor that triggered the payment, the assembly and the reselling as a finished product, and not the importation itself. So Article 2 only works when we really talk of crossing the border, of imports. Article 3 works with any payments that relate to internal events, something that happens within the borders. And most importantly, I even emphasize it here, underlined, it doesn't matter if you pay something at the border or already after the border has been passed. There can be border charges that are paid when the product has already been imported. So, for instance, it can be the case that customs authorities permit you import the product under the domestic customs legislation, and then you can resell it already 10 times, but you are still under an obligation to pay the customs officials. And you will pay the customs officials. This payment that you make in 3-5 months from the moment of importation, if the legislation permits, would still remain the border measure because it was charged on the fact of importation. Whereas any obligation that is based on some internal factors will be an internal charge, even if the foreign product has to pay it at the border. Let's take the example of excise taxes. We already mentioned excise taxes several times. You all know excise taxes in everyday life. You see the bottles of alcohol with excise tax stamps demonstrating that the tax has been paid. You see every pack of cigarette with an excise stamp on it. So when a foreign product enters the territory, when does it pay this excise tax? At the border. The foreign product is not permitted to enter the territory before it pays, before the stamp is placed on, say, same cigarettes or on wine or any other alcohol. So the excise tax will be charged on a foreign product at the border. But does it make it a border measure? No, because we need to understand what is the event triggering the payment of the excise tax. I don't know if you know much of tax law or generally the system of taxation. Excise tax is a tax on domestic consumption. So excise is the tax that consumers pay for the fact of consumption within a territory. Of a car, because some cars are also subject to excise taxes in Russia even, of a bottle of alcohol or a cigarette. So all this is subject to a tax because of consumption within the territory. So what is the event that triggers the payment? Consumption. Is it an internal event? Yes, it is an internal event. And if the product then gets sent back from the country, exported from the country, then you could even seek the rebate, the return of the excise tax if the product was not consumed within the territory. So actually what is interesting is that despite the fact that tax is paid at the border, it remains an internal measure. So it will be judged, qualified, understood, interpreted under Article 3. It will fall under the disciplines of Article 3, and the applicable rules will be national treatment rules. Whereas the fact of payment at the border doesn't change the qualification. While payment for importation and in connection with importation, and those payments are not only customs duty, the same anti-dumping duty is a payment for the importation. It remains a border measure. It will not be subject to Article 3 disciplines. Clearly, all those payments under Article 2(c), those charges at the border, which we charge only foreign products, those remain to be border measures, and they will not be subject to 3.2 say. So these are the two cases which were essential for me to show you how different parts of GATT interplay: Article 3 and Article 1, Article 2 and Article 3. Now, trying to make the conclusion out of the China Autoparts case, let's just see this short title, short table, and let's make conclusions based on what we just discussed. So what are the rules applicable to border measures? We understand that border measures are those regulated by Articles 2, schedules, 11, quantitative restrictions, general elimination of quantitative restrictions, and Article 13, non-discriminatory application of those quantitative restrictions. These only apply to border measures, and internal measures are regulated by Article 3. This is essential that you don't confuse the two, because if you start applying Article 11 to internal measures, you make a mistake. Recall the examples of these quotas in domestic shops. When domestic shops say they will not sell more than 30% of the overall amount of products as products of foreign origin. So they will only accept 30%. Well, if shops say that, it's their decision, maybe it is not attributable to the state, but say a legislator, the State Duma or whoever, the European Commission, European Parliament, they enact a legal requirement that all shops can only sell no more than 50% of foreign products. The rest 50% should remain for the domestic producers. We feel it's a quota. We have a big temptation to apply Article 11 because Article 11 talks of quotas. But we should resist this temptation because Article 11 does not really regulate internal measures. Article 11 only regulates border measures. And when we talk of border measures, then we use this word quotas in this correct sense of Article 11. Article 2 only applies to border measures. Wherever we talk of anything that falls within the scope of internal measures, apply Article 3, 3.2 or 3.4. Resist the temptation to apply any other provisions. And summing up, Article 1, does it apply to border measures? Yes, clearly so. It applies to customs duties, customs formalities, all charges in connection with importation, transfer of payments, and so on. But keep in mind, it also applies to border measures to the extent that the reference was made. Yes, it does apply to internal measures, but keep in mind the caveat with reference to EC vessels case that it only applies to those internal measures which are subject matter to Articles 3.2 and 3.4. It does not apply to other border measures in any other parts of Article 3 provisions. 3-point methods referred to in 3.2 and 3.4. That is it. So actually, that is likely to be it as for national treatment. That is likely to be it as for the most two fundamental non-discrimination provisions, Articles 1 and 3, MFN and national treatment.